I'm Ted Carr with Berkeley Law and Technology Group, and today's video is going to focus on state registration and federal registration. Now, when you first start using your trademark in commerce, you're automatically protected by common law rights. And we covered that in another video. Common law rights are covered under basically state law and the Federal Lanham Act. Well, you can also register your mark in a particular state in which you're doing business or with the Federal Patent and Trademark Office. And there are criteria in which you need to decide whether or not it makes sense to register at the state level or at the federal level. If you have a business that has interstate commerce or is in interstate commerce, then I would recommend the federal registration process. The federal registration process grants you, assuming you're able to get your mark registered, you apply through the U.S. Patent and Trademark Office. An examiner reviews the application, will perform a search, and then we'll let you know if the mark has been approved for publication. Once it's approved for publication, it gets published for a month, assuming no opposition during that 1 month period. We then will get a notice of allowance in due course. And then, assuming we had filed the mark based on actual use in commerce, then we would receive a notice of allowance or get the notice of allowance and then registration. Now, if we filed based on an intent to use the mark in commerce, which gives you a priority date, but you haven't used the mark yet, and a lot of times you'll do that because you're starting your branding process, or you are starting, you've got to roll out your marketing, or there's some more manufacturing that needs to be done, but you want to preserve the name, that brand associated with the product or service. Then you file intent to use. After you file intent to use, you get through the prosecution process with the examiner, you get a notice of allowance, then you can file a statement of use. And the statement of use basically is just showing a specimen, or is a specimen showing that you're using your mark in association with the goods or services that are in your trademark application. Once the mark registers, you can use the Circle R, and that gives you a presumption of the right to use the mark exclusively throughout the United States, which is the kind of the broadest protection you're going to get under the law in the United States. Federal registration gives you exclusivity throughout the United States. The only exception to that would be if someone beat you to using that same mark or a very similar mark in association with similar goods or services. Say you file for registration of a mark in Austin, Texas, and you have interstate commerce, and so you can support a federal registration, and you get that registered, and you find out later that someone had started using that mark in, say, Los Angeles and in the greater Los Angeles area, but not outside of that area. Their common law right would supersede your federal registration in that area, and that could be problematic for you if you want to expand into the Los Angeles area, for instance. So that's often why we perform searches, so we understand the scope of who's using a mark before we file the trademark application. And then we can also determine what our risks are if our business plans to expand in an area where someone was previously using a mark, even if it wasn't registered. Now, you can also register at the state level. Why would you register at the state level instead of the federal, instead of the Federal Patent and Trademark Office? Well, if your business is not of the nature that it's interstate commerce, in other words, it's only in that state, and there are a number of exceptions where, like, restaurants oftentimes can claim interstate commerce because people travel in from out of state and frequent restaurants that way. But let's say you have maybe a roofing business and you only do business in Austin. Well, then you might want to consider a state registration as opposed to a federal registration. Or you do business in Austin, San Antonio, and Houston, but not outside of the state of Texas. Well, then state registration would afford you rights in the state, much like the federal gives you the exclusive right to use throughout the United States. The state registration would give you the exclusive right to use within the state. Now, there are some nuances with state registration. Some states, it's just simply a registry where you file and there's no review by an examiner. Some states, like Texas, they actually do have an examination process, and they look at the federal registry as well before they'll grant state registration. So if you have more questions about registering your trademark at the U.S. Patent and Trademark Office or in a given state, feel free to reach out to us and be more than happy to answer any questions. My email is tkarr@bltg-ip.com. Thank you.